Well, welcome everybody to our webinar all about Child Status Protection Act, the CSPA. Let me start by pointing out the obvious, which is that the CSPA can be very complicated. So don't feel bad if you don't understand all of it now. Unfortunately, it also got a little bit more complicated in February when the USCIS changed the rules in terms of how you and when you calculate adjusted age. It also changed the definition of extraordinary circumstances for when you can get an exception to the one-year filing rule. So we're going to cover all that. There are actually a lot of you on this webinar. Some of you may be familiar with the CSPA and just want to update on what the current rule is. Some of you understand maybe most of it, but want a refresher on all the rest of it. And some of you may be new to immigration law, or you may have put off learning about the CSPA and you're thinking maybe finally this is the time you understand it, right? So before we get going, I'm going to introduce myself. I'm Charles Wheeler. I work at Clinic. I'm broadcasting live from Northern California. And with me is Christina. Christina, welcome.
Hello, Charles. Hello, everyone. I'm Christina Karpinski. I'm the managing attorney in Clinic's training and technical assistance section, and I am outside of Boston in Massachusetts. So welcome, everyone.
All right, so what are we going to talk about? Well, you see up there on the slide, we're going to be spending most of our time actually covering family-based immigration. Why is that? Well, most of you are involved in family-based, and actually that's where the CSPA has most of its application. So we're going to be starting off with the basics here, talking about what is actually the easier part, I think, immediate relatives, how they stay immediate relatives. We're then going to be talking about the preference categories, the F2A category in particular, and derivatives. We're going to be contrasting how the USCIS interprets this thing called adjusted age with what the State Department uses, and that's going to be a little confusing. So we're going to have to spend a little bit of time explaining how that works. We're going to be talking about this one-year filing requirement, which is required in order to lock in your age if you are in the F2A or the preference category, as well as this new exception or definition of exception the USCIS applied. And then finally, talking about what happens when the petitioner naturalizes and what you can do to opt out of this automatic conversion from the F2B category to the F1 category. And then we're going to be going through kind of lightly because it's not all that complicated. We're going to be talking about how the CSPA applies with VAWA, with refugees and asylee derivatives. We're also going to be talking about how it applies in the widower context. And then finally, with SIV Afghans. All right, what we're not going to be talking about is how it relates to employment-based cases, because most of you, I assume, are not in that business, nor are we talking about DV lotteries. But a lot of what we are talking about in terms of derivatives also applies in the employment-based categories as well. All right, so what you see up on the screen is kind of a blueprint of what we're going to be following. A little bit of a sneak preview here. We're going to be diving into all of this, obviously, much deeper. But you see with family-based cases, you got sort of two things to remember. One deals with the immediate relatives, the general rule. Christina is going to be talking about all the various permutations of that. I'm going to be talking about the F2A and the preference categories and derivatives. And then we're going to be talking about, with VAWA cases, we're going to talk about how the I-360 is the petition that we're going to be following. And if the petitioner is a victim where the spouse or parent is a U.S. citizen, then the self-petitioner is going to be an immediate relative if they are under 21 on the date the I-360 is filed, or a derivative. Or if they are under 21 and the abusing spouse is a lawful permanent resident, then we're going to be following the same rules with the preference category and the F2A. Refugee and asylees work fairly simply and fairly easily It's the date that the petition, in this case, the I-589 for asylees or the 590 for refugees is filed. If the derivative child's under 21, then they're going to preserve that age. Widows and widowers, we're going to talk about how the I-360 is filed for a self-petitioner in that situation. Or if an I-130 was already filed, it's the date that the petitioner dies. What's the age of the child on that date? And then finally, the Afghan with special immigrant visas, if under 21, using the date the I-360 is approved. In other words, the adjusted age. All right, that's just a little bit of a warm-up. Why don't we start going here with the immediate relative category, and I'm going to turn it over to Christina to walk us through all the various options there.
Sure, thanks, Charles. So we know that a child of a U.S. citizen is an immediate relative if that child is unmarried and under the age of 21. But what happens when the child turns 21? Well, under CSPA, as long as the child was under age 21 when the U.S. citizen parent filed the I-130 petition, the child's going to remain an immediate relative, even if that I-130 is approved after the child turns 21, or that child immigrates after age 21. So the child's age is frozen on the date the I-130 is filed. To benefit under this rule, the person does have to remain unmarried. So that's important to know. If he or she marries, then they're no longer an immediate relative and would convert to the third preference. So the golden rule is, if an immediate relative, always an immediate relative, as long as the beneficiary does not marry before immigrating. All right,
Christina, I'm going to jump in here. We're having a little volume issues. I don't know whether you can either move closer to the mic or get a little, maybe I can take over here. We're having a hard time hearing
sorry.
you.
Can you hear me now? Is
You're
that better?
Pretty faint, unfortunately.
Okay, Charles, do you want to take over and I'm going to get off and get back on?
Okay. All right. So just a brief recap here. What Christina was talking about is if you're once immediate relative, you are always immediate relative. You don't have to worry about this 1-year filing requirement. If you're under 21 on the date the I-130 is filed, then you're safe, right? But there is always another way to become an immediate relative, and that, of course, is if your petitioner is a lawful permanent resident, and that petitioner naturalizes before you turn 21, you are still in the immediate relative category. Why? Because you then convert from the F2A category to the immediate relative. We've got a little example here. Marco, a lawful permanent resident, petitions for his daughter Maria when she's 18 years old. Marco naturalizes when Maria is 20 years old. And then what happened to Maria? She converted to the immediate relative category and remains a child, even if she immigrates after age 21, right? Once an immediate relative, always an immediate relative. All right, Christina, we see you are back. Let's see if we can hear you.
Okay, so we're talking, can you hear me okay? Yes, great. All right, so now we're talking about a married son or daughter is going to be in the third preference category, son or daughter of a U.S. citizen. If that son or daughter divorces and is under age 21 when the divorce is finalized, then that petition is going to convert to an immediate relative petition. The child's age is frozen on the date of divorce, and that child's going to remain an immediate relative, even if over 21 when immigrates. So again, to benefit under CSPA though, and remain an immediate relative, the child cannot marry. So let's look at another example here. Louis, a US citizen, petitions for his son Philip when he is 20 years old and married. Philip divorces before turning 21. Philip converts to an immediate relative and remains a child, even if he immigrates after age 21. Okay, so as Charles said, this is the easy part of CSPA. Charles, let's now talk about how CSPA works for F2As and derivatives.
All right, so yeah, this is the part that gives people a little bit of head scratching here. Your age is not frozen if you're in the F2A category on the date the I-130 is filed. Rather, it's frozen on the date that the priority date becomes current. But you're not using your biological or your chronological age, you're using your adjusted age. So we're going to talk about what that means for adjusted age. And it's usually priority date is current after the petition is approved, but sometimes it's current on that date. So what you have to do is make sure that the petition is approved and the priority date is current, whichever occurs later, right? All right, so adjusted age, not biological age. How do we get to adjusted age? Well, you subtract the period of time that the petition, the I-130 petition, was pending. In other words, they're going to be taking the approval date notice and subtracting, or at least comparing that to the priority date, the date it was filed, and you're going to be coming up with a number that's going to be months, years, days, and you're going to be subtracting that from the child's age on the date the priority date becomes current. The problem, and what is new now, it's not really a problem, but what you have to now factor in is what priority date chart. In other words, what whether it's going to be chart A or chart B, depending upon whether the child is adjusting status, in which case you're going to be using chart B more than likely, or whether they're consular processing, in which case it's chart A. And then we have this final thing that you have to seek lawful permanent residency within 1 year. So we're going to be walking through all this. We're going to be describing it and using some hypotheticals and defining also what is meant by chart A and chart B. The same formula in terms of applying this adjusted age applies to all the derivatives in both the family and the employment-based categories. So you see up there for family, it's the F1 for sons and daughters who are unmarried of U.S. citizens. It's F3, which are the married sons and daughters of U.S. citizens, and then the F4, which are the siblings, the children of siblings in the F4 category. And then the F2. F2 has, of course, F2A and F2B, and both of those can have derivatives. All right, so the same formula, if the child using the adjusted age on the date the petition is approved and the priority date is current is under 21, then they remain a derivative. But again, if they're a derivative, then they have to, of course, seek lawful permanent residency within 1 year. And why this is a little different is that a lot of people don't realize that it's the derivative who has to also initiate this by filing for adjustment of status or paying the immigrant visa fee. We're going to talk about what this means for consular processing. It's not enough that the principal has done something. The derivative also has to do this. What do we mean by the petition is pending before the USCIS? Well, naturally, it's filed and approved at some point, but it could have been denied. Could have been still under administrative review. It could be a motion to reopen or a motion to reconsider. That's still pending. Could be an appeal to the BIA. That, again, is still pending. But it doesn't include times when the consulate returns the petition to the USCIS. It also could include a petition to reinstate after the death of the petitioner. But these are sort of fine points. Most of the time, you don't have to deal with that issue. Another big difference, though, with derivatives is what happens on age out. And we're going to be talking about what happens when the F2A child ages out. They automatically move into the F2B category. Even derivatives in the F2A automatically convert to the F2B category. But with derivatives in the other preference categories, if they age out, then they move into nothing, nowheresville. They move into this black hole, and they have no immigration status. So anyway, we'll be talking about that more and using some examples just to make sure you understand what's happening here. So let's start with consular processing. We'll talk about adjusting in a minute. And you see there, to calculate the adjusted age, the priority date has to be current using chart A. That's what State Department has applied, and they have not changed their rule on this. It's been applied since the CSPA was first enacted. This has always been true. All right, so you can't calculate the adjusted age until chart A is current. But this what confuses some people. The NVC uses chart B for purposes of sending out this welcome letter and sending the fee bill and encouraging people to pay the fee bill, pay the affidavit support fee. All of that happens with chart B. But here's the deal: paying the immigrant visa fee or paying the affidavit support fee doesn't lock in your age, right? You're still aging until chart A becomes current, right? There's no clock stopping here. All that does is simply satisfy the 1-year filing requirement. All right. If the F2A child does age out, as I mentioned, they're going to convert automatically to F2B. This is in the regulations. It's been true for as long as no new I-130 needs to be filed. It's automatic. The same is true, and we'll be describing why this is true. If you're in the F2A category, but you're a derivative, then you age out. What happens? Then you automatically convert to becoming a principal beneficiary in the F2B category. And again, no new I-130 has to be filed. This is automatic. The problem is if you're a derivative in any of the other preference categories and you age out, as I mentioned, you fall into this black hole. And if you've already paid your immigrant visa fee with the State Department, with the NVC, then you can lose your fee if you lose your derivative status before chart A becomes current. All right, we're going to be coming back to all of these and illustrating them with an example. And let's do an example. Let's start out here with the F2A in the consular processing stage. Christina, you want to read this to me?
Sure. Maria, an LPR from Colombia, filed an I-130 for her son Hector on March 20th, 2022, and the petition was approved on March 20th, 2023. Hector's date of birth is July 7th, 2001. She wants her son to immigrate, but is concerned because he is now 22. Hector received a fee bill from the NVC in May of this year and wonders if he should pay it. You look to see if the F2A priority date in chart A was current for March of 2023. What advice do you have for Maria and Hector?
All right, so let's unpackage this thing. What's going on? Well, we tried to make it simple here. Remember, you've got to look to see how long the I-130 petition was pending. It was filed on March 20th, 2022, and it was approved on March 20, 2023. So it was pending 1 year. All right, we're going to keep it simple. It takes about a month from the approval of the I-130 petition for the USCIS to send that file to the NVC. That's when they send out the welcome letter and the fee bill, assuming chart B is current. So if it was approved in March of 2023, we just sort of said, okay, let's say that it arrived at the NVC and they sent it out in May. It could be April or May. We just picked May. All right, so you need to know 4 things. Whenever you're doing adjusted age, you've got to start with 4 things. If you don't know all 4 of them, then you can't do anything. First, you need to know the date of birth of the child. That's fairly obvious. You need to know the priority date. You need to know the approval date, that notice of approval. And then finally, you need to know when the priority date was current. And in this case, since we're doing consular processing, you have to look to see when it was current in chart A. All right, so how long was it pending? It was pending 1 year. When can you calculate the adjusted age? All right, so obviously it has to be current in chart A and the petition has to be approved, whichever is later. In this case, you look to see whether it was current in chart A for what month? For March of 2023. Why are we doing that? Because that's when the priority, that's when Hector's petition was approved. And you look to see if the chart A was current on that date. If so, that's when you're going to be calculating the adjusted age. And that's also when the 1 year filing requirement starts. All right, So what was his adjusted age on March 20th, 2023? And was the priority date current? So this is March 2023, chart A. But let's back up. For those of you who are new to all this, let me explain what's going on here. In September 2015, Department of State and USCIS announced a revision to the visa bulletin, and they created two charts. They created a chart A, which is what we knew before. That was final action dates, chart A. But they also created a chart B, which is dates for filing chart, right? So since October 2015, Visa Bulletin has actually featured these two charts. The USCIS designates every month which of these charts you're going to be using for purposes of filing. In other words, are you going to be using chart A, which we used to use, or you'll be using this new chart B? So you have to go to the USCIS website. You have to see which one they're going to be using. Fortunately, USCIS has been allowing chart B for adjustment of status filing ever since the beginning. And so probably they're going to be continuing to do that until something major happens. The Department of State, however, has been using chart B for purposes of when they initiate things, when they send out the welcome letter. This used to be sort of informal on their part and kind of secret, but now they sort of brought it into the open. And this is chart B. Chart B is typically about 1 year before chart A becomes current, but not always. All right, so that's when the filing fee is paid, but it's not, of course, with consular processing when you can do the calculate this. So you have to look at chart A, and here's chart A, and it shows what? It shows that it's current in chart A. You see a big C there right across the board. That means current. That keeps it simple. And chart B, of course, for that same month of March 2023, also indicates a current. It's current in chart A, then you can pretty much guarantee it's going to be chart B is also going to be current. And that's, again, when the NVC is going to send out this welcome letter and when you can pay the immigrant visa fee. All right, so this is the template that I use to determine adjusted age. You can do this any way you want. But here are the four things you need to know. Date of birth, I put it up there, July 7th, 2001. Date the petition was filed, that's the priority date, that's March 20th, 2022. Date it was approved, March 20th, 23. What was the time it was pending? Now, oftentimes you're going to need to do a little calculation. Timeanddate.com also tells you what the difference between two dates are. So you can plug it into that. But here we made it simple. It's 1 year. Then, of course, the question is, when did the priority date first become current in chart A, assuming that the petition has already been approved, right? And remember, we looked at chart A, and for March of 2023, it was current right across the board. So that's the date that what? That's the date you can do the calculation of the adjusted age. And it's also the date, as we'll talk about in a minute, when this 1 year filing requirement starts. All right, so what do you do with this 1 year period when it was pending? Well, you can either subtract it from the child's age on the date that the petition was approved and the priority is current. What I like to do, though, is simpler in my situation. I like to add that period of time to the child's date of birth. Why do I do that? Well, addition for me is easier than subtracting birth dates, right? And I also do it because that would allow me to know exactly when this child is going to age out. In other words, if I do that, and then I know that if the chart A in this case is not current by that date, then the child is aged out. So the child can ask me, when am I going to age out? And you know exactly. You don't have to say, well, I can't do anything until chart A becomes current. All right, so in this case, you simply add 1 year to the child's date of birth. So the child, instead of being born on July 7th, 2001, he was born on July 7th, 2002. And then you just simply add 21 years to it. And that's going to tell you when he's going to age out for CSPA purposes. Of course, it's July 7th, 2023. And you compare that to when the chart A became current. and the priority date was approved, and the petition was approved. And then we know that it was March 20th, 2023. That's when both the petition was approved and the priority date was current in Chart A. And you look at that and you go, okay, on March 20th, 2023, he was still under 21 using his adjusted age. So what? So you say, congratulations. You are still in the F2A category. However, we have to do something. We have to what? File to seek permanent residency within 1 year. We'll describe in a minute what that's all about. All right, so that was the state of play, but things have gotten a little bit more complicated. Certain questions arise. First question that usually comes up is, does it matter if Chart A is no longer current when you pay the immigrant visa fee or when you've already paid it? And in fact, Chart A has retrogressed over the summer of 2023. Those of you who've been following this might see a little bit of horror here in terms of how backlogged it was, particularly in June and July. All right, and the answer is no. The adjusted age, remember, is calculated when the priority date becomes current, and you get locked in to that. It doesn't matter what happens if there's what we call retrogression in Chart A. You are locked in as long as what? As long as you can pay the immigrant visa fee. And the immigrant visa fee is paid what? When Chart B is current, right? So the next question is, does visa retrogression in Chart A affect the ability to pay the immigrant visa fee? And the answer is no. Even retrogression in Chart B doesn't affect your ability to pay the immigrant visa fee. Why is that? Because let's say in March, remember, file gets sent to the National Visa Center. They send out the immigrant visa fee bill. Doesn't matter if Chart B retrogresses, you can always pay the immigrant visa fee if you've ever gotten a notice saying pay it now. Doesn't matter if there's further retrogression. Now, retrogression may affect those who are adjusting status, and we'll talk about that in a minute. But here, that's not a problem. All right, can you still age out after paying the immigrant visa fee? And here is the problem. Remember, Chart B says, come on in, let's pay the immigrant visa fee, let's get going here. But that doesn't lock you in, right? You can't calculate the adjusted age until Chart A becomes current, right? So Chart B and this immigrant visa fee is a little bit of a teaser in the sense that, in fact, you could age out even after paying the immigrant visa fee, right? And that's exactly why the CSPA doesn't apply this, or the USCIS doesn't apply this interpretation with adjustment of status, because they didn't want you to lose your filing fee. All right, if you age out after paying the immigrant visa fee, do you get a refund? I love this question. And the answer is, are you serious? Of course not. When is the last time you ever heard of government giving you a refund? All right, let's do another example here. In this case, we changed the dates of the priority date and the notice date. Christina, why don't you read this one to us?
Sure. So Maria, an LPR from Colombia, filed an I-130 for her son Hector on June 20th, 2022, and the petition was approved on June 20th, 2023. Hector's date of birth is July 7th, 2001. She wants her son to immigrate, but is concerned because he is now 22. Hector received a fee bill from the NVC in August of this year and wonders if he should pay it. You look to see if the F2A priority date in Chart A is current and discover that it hasn't been current since May of 2023. What advice do you have for Maria and Hector now?
All right, so what's going on? Actually, before we go to that visa bulletin, let me just sort of unpack this one. All we did here was change the priority date and the approval date from March to June, right? And notice that we kept it 1 year in terms of how long it was pending, just to keep it simple. All right, so remember, there's 4 things you need to know. You need to know Hector's date of birth. That's July 7th, 2001. That didn't change. How long was it pending? Well, the difference between the priority date and the approval date, that's still 1 year. And when can you calculate the adjusted age? Well, in this case, instead of doing it in March, we're going to be looking at chart A for June, right? Because that's the time when both the priority date was, well, that's the date that the petition was approved, and that would be the date if chart A is current, right? So when was the priority date current? So let's look at the chart A for June of 2023. And remember, the priority date is what? June 20th of 2022. So if you do that, you see what? The F2A is not current. The priority date is not before the date on the visa bulletin. So it wasn't current in chart A. And if in fact you do further discovery, you find out that it's still not current now. But let's look to see what was going on in August when the NVC got the approved file from the USCIS. You see that chart B was current in August. And that's when, at least according to this hypothetical, the NVC sent out the fee bill. So should Hector pay it? All right, so let's do this sort of walkthrough using my template, and we'll see what's going on here. All right, date of birth, July 7th, 2001. Date petition was filed June 20th, 2022. Date it was approved, June 20th, 2023. Again, all we did was change it from March to June, pending for 1 year. Date, the priority date was current in chart A. All right, we don't know. We don't know. It certainly wasn't current in June. We looked there. And if you keep following this, you'll find out that it's still not current. It wasn't current in June, not current in July, August, or even September, October. So you can't calculate the adjusted age yet. All right, so what's going on? His adjusted age is July, date of birth is July 7th, 2002. You had 21 years. He aged out. You know exactly when he's going to age out. He aged out on July 7th, 2023. In fact, this I-130 petition was filed 2 weeks before Hector turned 21. And while Chart A and Chart B were current for a long time using F2A, it suddenly became not current over the summer. So this is why I like adding date of birth to the adjusted age, the period of time the petition is pending, so I know exactly when he's going to age out. I don't have to wait for Chart A to become current to tell him the bad news. All right, must he still pay the immigrant visa fee if the NVC has sent it? And the answer here is yes. Why is that? You don't want to have this be terminated. All right, he automatically converted to the F2B category, but the last thing you want to do is to have the National Visa Center terminated for failing to act within 1 year, which they can do under another section of law, 203G. So you don't want that to happen. Go ahead and pay the immigrant visa fee. No new I-130 needs to be filed, automatic conversion, and make sure you respond to all further NVC emails. All right. What if Hector is a derivative in the F2A category? Why don't you read me this one, Christina? It changes a little bit, but not a whole lot.
Sure. So we have Maria again from Colombia, an LPR, filed an I-130 for her spouse, this time on June 20th, 2022, and her son Hector was named as a derivative. The petition was approved on June 20th, 2023. Hector's date of birth is July 7th, 2001. She's concerned because Hector is now 22. Maria's spouse received the fee bills from the NVC in August of this year, but not Hector. You look to see if the F2A priority date in Chart A was current in June, and you discover that it wasn't. What advice do you have for Maria and Hector?
So, Christina, unfortunately, your sound is fading out. Good news is people can read the slide. They don't need you to read them to them, but you might want to consider leaving us momentarily and then coming back on. That seemed to work for a while. All right, what's going on here? Well, it's the same facts as the prior case, except what? Hector's, instead of being the principal on the I-130, he is now a derivative in the F2A category. And remember, Hector turned 21 and he aged out. But did he lose derivative status? And the answer, of course, is yes. Remember, he's adjusted age made him turn 21 on July 7th, 2023. And chart A was not current, so he aged out. Did he convert as a principal in the F2B category? And the answer is yes, he did. And why is that? Well, the CSPA did a number of things. And one of the things it did was to have this language in section 203H3 of the Immigration Nationality Act. And what does that say? It says the following. The alien, that's their word, not mine, the alien's petition shall automatically be converted to the appropriate category, and the alien shall retain the original priority date issued upon receipt of the original petition. Wow. There's a lot to try to figure out in that paragraph. Number one, you're talking about automatic conversion. When you talk about automatic conversion, then you know that there's no additional petition that needs to be filed, right? It just happens automatically. But then they start talking about retention of original priority date. The only time you would be talking about retention of priority dates is when you filed a second petition, right? So this is what's called internally inconsistent and frankly, very confusing. Because if you're a derivative in, let's say, the F3 or the F4 category, what happens when you age out? What appropriate category do you move into? Well, as I said, you move into this black hole. There is no category. So the Board of Immigration Appeals interpreted this fairly narrowly in the sense that they said, we don't make any sense out of this, but the only way we can rationally imply it or interpret it is to apply it only to the F2A category, because in that case, we've got a regulation that specifically says you convert to the F2B category. Went all the way up to the Supreme Court, believe it or not. And Supreme Court shook their head and said, we can't make any sense of this either. But it looks like the board has at least made an attempt. So we're going to go with what the Board of Immigration Appeals said, right? Only the F2A convert automatically to the F2B. Everybody else, they're over 21 using their adjusted age. On the date the priority date becomes current, they're going to lose their derivative status. So in this case, it's good news for Hector. He was in the F2A category. So he automatically converted to the F2B, as I indicated. He started out as a derivative. He lost his derivative status, but the good news is he became a principal beneficiary. In the F2B category, no new I-130 needs to be filed. Obviously, it's the same priority date. And I'm going to read you one here because what it does is just sort of clarify what's going on here. Maria, a lawful permanent resident, filed an I-130 for her spouse with their son, Hector, named as a derivative. When the F2A category in Chart A became current, Hector was 22 and aged out. Maria doesn't need to file a second I-130 for Hector because he automatically converted to the F2B. And that's good news. It saves you as the practitioner from having to, get back to the petitioner, cough up another filing fee, fill out another form, automatic conversion. And that's based on the statute, INA 203H3. But what if you didn't understand that? What if, in fact, Maria did go ahead and file a second I-130 for Hector? What happens? Hector retains that original priority date from that first I-130 petition. And that's based on what? That's based on a regulation that you see there, 8 CFR 204.2 4. And that is because that regulation preceded the Child Status Protection Act. And we've been relying on that for years. As long as you include that first I-130 petition and you explain that the derivative aged out before the principal beneficiary was able to immigrate, you were able to basically pay another fee, but you got to retain that earlier priority date. All right, what about derivatives in the other preference categories? Christina, let's see if your microphone is working now.
Okay, how's that?
It's
Is that
kind
better?
That's maybe if you get close enough, that might work.
Okay. How's that? All right, let me read this. So you want me to read Maria or the next slide?
Oh, next slide, sorry.
Okay. So Maria, a U.S. citizen, filed an I-130 for her brother on February 20th, 2008, with her brother's son Hector named as a derivative. The petition was approved on February 20th, 2009. Hector's date of birth is July 7th, 2001. Maria is concerned because Hector is now 22. Maria's brother just received fee bills from the NBC, and he wants to know if Hector is still a derivative. You look to see if the F4 priority date is current, is in Chart A is current, and you discover that it isn't. But it is current in Chart B. What advice do you have for Maria, her brother, and Hector?
All right, so what's going on here? Well, you have a derivative situation for Hector, but he's not a derivative in the F2A category. He's a derivative in the F4 category. The February visa bulletin shows that it's not current in Chart A or Chart B. And you look to see whether the October visa bulletin, because that's where we are, is current in Chart B. And what do you find out? Well, here is the October Chart B. You've got a priority date of February 20th, 2008. And you're looking at the F4 category under the all nationalities down there in the lower left-hand corner. And you see a date there of March 1st, 2008. And remember, you've got a priority date of February 20th, 2008. So again, this is Chart B, not Chart A. So it first became current in October using Chart B, October 2023. But let's see if Chart A is current. And here's Chart A. And again, you're going to look down at the lower left-hand corner for the fourth preference. And you've got this priority date. What's the priority date? It's February 20th, 2008. That is not before 22nd of April, 2007. So the F4 is not current using Chart A. But you also know that Hector aged out on July 7th, 2023. He is in no category now, right? He dropped off the face of the map here. And that explains why he did not get a fee bill. And when his father, the principal beneficiary, becomes a lawful permanent resident, what can he do? He can file a new I-130 petition for Hector in the F2B category, but there's no retention of priority date, and the F2B category is backlog quite a ways. But let's change the facts slightly, and let's say his adjusted age, instead of being July 2023 when he turned 21, it's December of 2023, or maybe even March or April of next year, 2024. Does he pay the immigrant visa fee bill, right? Remember, Chart B shows he's current. The National Visa Center is going to send out this invitation to pay the immigrant visa fee bill. What if he pays it, but then Chart A still doesn't become current until his age out date, whatever that is, December of 2024 or whatever that 1 year period is. In that case, he would lose, of course, the fee bill. But if he pays it, then of course, you know, you're just sort of hoping that Chart A does become current in that period of time. All right, that's it for consular processing. Sorry, it was so long and boring and really technical. Let's make it a little easier, and we'll talk about Chart A and Chart B for adjusting status. All right, in this case, we're talking about really this February 14th, 2023 change in interpretation. What the USCIS is saying that for filing purposes, we're going to either use Chart A or Chart B, and we're going to let you know. But as I indicated, USCIS has been allowing Chart B for filing purposes way back from September or October of 2015. So we are assuming that that's going to continue. But again, every month you have to look to make sure that that's still true. All right. So this is new. Used to be that you have to look at Chart A. And again, you're going to be calculating this adjusted age, and the one-year filing requirement starts when Chart B becomes current. All right. If you're eligible applicant, you file for adjustment of status, but the later the visa is not available for issuance of Chart A, then what happens is the USCIS holds on to that application until Chart A becomes current, and until that adjudication takes place. And during that whole period of time, you get what? You get work authorization, you get to apply for advanced parole. So you get all the benefits. If you were current in Chart B and you're able to pay, and you do file for adjustment, then you're locked in. That's wonderful. Even though Chart A is maybe backlogged and hopelessly backlogged, who cares? You're still getting all the benefits of it. All right. But again, remember that one-year filing period starts using Chart B, so you have to be on your toes here. But the good news here is that you will not lose your filing fee, right? Because if Chart B is current, you pay it. Chart B is not current, you're not going to pay it. That's true for both F2As, it's true for derivatives. It's also true for derivatives in all the other categories as well. If Chart B is current, you pay it, you're locked in. That's good news. If it's not current, then you don't lose anything because you can't pay it. All right, let's do an example here just to make sure you understand what's going on with adjustment of status and how that differs from consular processing. Christina, let's try again here.
Okay, Maria, an LPR from Colombia, filed an I-130 for her son Hector on June 20th, 2022, and the petition was approved on June 20th, 2023. Hector's date of birth is July 7th, 2001. Hector would be eligible to file for adjustment of status if his priority date is current, since he recently was admitted on a tourist visa. You look and see that the F2A priority date was current in Chart B in June of 2023, and that USCIS is still allowing Chart B for filing purposes. But Chart A wasn't current and still isn't. What advice do you have for Maria and Hector?
All right, so we're going to be looking at Chart B here in a minute, but before I do that, let me sort of tell you what's going on here. His adjusted age is measured on June 20th, 2023. Why is that? That's when Chart A, hopefully, not Chart A, sorry, that's when Chart B hopefully was current, and that's when the petition was approved. Doesn't matter how long it takes for the priority date to become current in Chart A. If it is current in Chart B and you file, as long as Chart B is current, then what's going to happen? USCIS is going to hold on to that petition. They're not going to schedule the immigrant visa interview, or if they do, and they're going to pass you along, you're still not going to be issued an approval notice until Chart A becomes current. But again, during that whole period, you've got work authorization, you've got the ability to apply for and receive advanced parole. If the priority date retrogresses, though, in Chart B, then you might have a potential problem if Hector didn't file when it was current. And you can't file for adjustment of status until Chart B becomes current again. All right, so we'll deal with that in a minute, but let's walk through and find out if, in fact, Chart B was current in June of 2023. And we look here, And we see the good news is that for the F2A category, it was current using chart B for June, so he can file for adjustment of status as long as it's still current in chart B at the date that he wants to file. All right, so let's go back to this template that I use here. And we see his date of birth, July 7th, 2001. Petition was filed June 20th, 2022. It was approved 1 year later. And the priority date in chart B was current for June of 2023. So that's when we do the adjusted age. We have to do that. We don't have a choice here. And that's, of course, when that 1 year filing period starts as well. So again, you subtract 1 year, you get his adjusted date of birth. You know that he's going to turn 21 on July 7th, 2023, using that adjusted date of birth. And you know that he was under 21 on June 20th, 2023. So he is locked in to the F2A category as long as he does what? As long as he files and seeks permanent residency within 1 year. But now here we are in October. Is the priority date current in chart B? Can we file for adjustment of status? I'm sorry, is it current in chart A? It is current in chart B, right? Here's chart B. It shows a priority date of June 20th, 2022, and that is before the date on the F2A category. You see up there all nationalities, and you see a date there of September 1, 2023. His priority date is June 20th, 2022. That's before September 1, 2023. So it's current for October using chart B. We now know that he was current back when it was approved, and we know that he's current now, so he can still file. But what if it wasn't? What if chart A, in fact, was not current in October? I'm sorry, chart B is not current. What if it's retrogressed for October? So we're going to discuss that when we talk about visa retrogression. Remember, it doesn't affect people consular processing, but it could affect people who are adjusting status. So hold on to that thought. We've been talking a lot about this 1 year filing requirement and what you need to do, but let's make sure you understand all the various options you have for purposes of meeting that 1 year filing requirement. Christina, let's see if your mic is working.
Sure. Okay, so to benefit under CSPA, as Charles said, the beneficiary must seek to acquire LPR status within 1 year of the visa becoming available. And the term seek to acquire has been narrowly defined by USCIS and the Department of State. According to the two agencies, seeking to acquire includes filing the I-485 application to adjust status, filing the Form 824 application for action on an approved application or petition. If you're not familiar with this form is used to notify the Department of State that a principal beneficiary has adjusted status and consular processing should begin for a derivative beneficiary. Other ways to seek to acquire include filing the DS-260, that's the online immigrant visa form, or paying the immigrant visa fee or the affidavit of support fee. If the beneficiary fails to seek to acquire status within a year and no exceptions apply, we'll talk about the exceptions in a moment, then CSPA protections won't apply and the biological age will control. So an F2A will become an F2B, or a derivative may lose derivative status. So before we get to the exceptions, let's first talk about when the 1 year filing requirement starts. So if the beneficiary is consular processing, 1 year will start when the priority date is current in chart A, or the date the petition is approved, whichever is later. If the beneficiary is adjusting status, Based on the recent change in USCIS policy, the 1 year will start when the priority date is current using Chart B, and that's if USCIS is allowing the use of Chart B for filing adjustment applications that month. And as Charles has said, they've been allowing us to use Chart B for many years now, or the date the petition is approved, whichever, again, is later. So what this means is that applicants must now really pay attention each month to whether the USCIS is allowing use of Chart B for filing purposes. And if so, that 1 year period begins on that month, not when the priority date becomes current using Chart A, as was the case under the prior policy. Okay, so let's now talk about the exceptions to the 1 year requirement to seek to acquire. So what does it mean to seek to acquire LPR status? This has been interpreted by the Board of Immigration Appeals in a case called Matter of O. Vasquez. There were a few unpublished BIA cases that came out before this case that provided a broader interpretation of the phrase, but this is a published decision. This is the legal authority on this issue. The decision's from 2012, and it involved a derivative child who had aged out of the F2A category for failure to file for adjustment of status within that 1 year time period. The beneficiary argued he had satisfied this requirement because his parents had consulted a notario within the year period about filing for adjustment. But the BIA looked at the phrase sought to acquire, and in this case found that the interpretation of USCIS and the Department of State requiring the filing of an application or the paying of a fee, BIA said this was a reasonable interpretation of the law. So the board found that defining it in this way promotes consistency, predictability, and that these are important principles in immigration law. However, the board did carve out two important exceptions to this rule. First, where the beneficiary attempted to file an application, but it was rejected for procedural or technical reasons. In those cases, failure to meet the 1 year rule would be excused if the applicant filed within a reasonable period of time after the application was rejected. The second exception is when the beneficiary can demonstrate extraordinary circumstances that prevented the filing on time. A few years after this BIA decision, USCIS issued a policy memo on what constitutes extraordinary circumstances. It's now incorporated into the USCIS policy manual at volume 12, part 8. Chapter 7, so I would encourage you to look at it. We have also gotten some additional guidance on this exception, but let's just talk for a moment about what the USCIS policy manual says. It says, in order to establish extraordinary circumstances, the applicant must demonstrate that the circumstances were not created by the applicant through their own action or inaction. The circumstances directly affected the applicant's failure to seek to acquire within that 1 year period, and the delay was reasonable under the particular circumstances. And some examples of extraordinary circumstances that may warrant a favorable exercise of discretion, because this is discretionary, include serious illness or mental or physical disability of the applicant during that 1 year period, a legal disability such as where the applicant has suffered from a mental impairment during that 1 year period, instances where a timely adjustment was rejected by USCIS as improperly filed and then was returned to the applicant for corrections. The deficiency was corrected and the applicant refiled within a reasonable period of time. Extraordinary circumstances could also include death or serious illness or incapacity of the applicant's attorney or legal representative or a family member. Also, ineffective assistance of counsel could be an extraordinary circumstances where certain requirements are met. So to be considered an extraordinary circumstance, the applicant has to do a few things, has to submit an affidavit explaining in detail the agreement that was entered into with the representative regarding the actions to be taken, what information, if any, the attorney or legal representative provided to the applicant regarding the actions. Also, they have to show that they made good faith efforts to inform the representative of these allegations brought against them, and the representative must have been given an opportunity to respond. The applicant also must indicate whether a complaint has been filed with the appropriate disciplinary authorities about any violations of the legal or ethical responsibilities of that representative, or if not, if no complaint was ever filed, then explain why a complaint was not filed. Okay, so what else can be considered an extraordinary circumstance? Well, USCIS updated its policy manual on August 24th and will now consider the February 14th, 2023 policy change that Charles explained as an extraordinary circumstance for failing to seek to acquire LPR status within a year of a visa becoming available in Chart B, provided the delay is reasonable under the circumstances. So you still have to show it's reasonable. And the reasonableness of the delay is going to be determined from August 24th, 2023. That's the date that this change in policy came into effect. So under the policy before February 14th, 2023, some beneficiaries who were permitted to file under Chart B, the filing date chart, they may not have filed for adjustment because, remember, under that previous policy, USCIS could not calculate the CSPA age at that time. They couldn't calculate it until an immigrant visa became available based on Chart A, or maybe they didn't file because USCIS would have calculated the adjusted age to be over 21. Now, if these individuals file based on Chart B, or maybe they have already filed, they may be unable to meet the 1 year sought to acquire requirement, right? And maybe the 1 year has already passed. But if that's the case, USCIS will consider this delay as an extraordinary circumstance as long as they consider it reasonable. One last point on this, USCIS considers applicants who had adjustment applications pending on February 14th, 2023 to have satisfied the sought to acquire requirement if the applicant applied for adjustment of status within 1 year of the visa being available based on Chart A, as was the prior guidance. All right, so that's extraordinary circumstances. Let's now move on to visa retrogression. We talked a little bit about it. Charles talked a little bit about it, but let's talk a little bit more about this, Charles.
All right, so we're going to return to this issue. Remember, visa retrogression doesn't affect people who are consular processing. Why is that? Because the NVC, if they issue a fee bill, because Chart B is current, you can always pay that. You have that 1 year window within which to pay it. Make sure you do that. Otherwise, you're facing 203G termination, right? So retrogression in Chart B has no effect on your continuing ability to pay that immigrant visa fee. But it does affect adjusting status. Why? Because you can't file for adjustment of status if Chart B is no longer current, right? So Chart B became current, then there was this retrogression. And we saw that in Hector's case. We'll go back and make sure you remember what was going on there. In that case, we're going to hypothetically say that Chart B, although it was current when the petition was approved, and he could have filed then, now we're in October, and Chart B is no longer current. He has to wait for Chart B to become current again before he's able to file. If he can do that, and you're still within that 1-year window, which started in, I think, in June of 2023, then you're fine. But if it doesn't become current within that 1-year window, what the USCIS is saying is that a new 1-year window opens up again. But the bad news is you have to recalculate your adjusted age on that date. All right, so let's do an example here. We're just changing the facts slightly to make October visa bulletin and chart B no longer current. Christina, you want to read this?
Sure. Maria, an LPR from Colombia, filed an I-130 for her son Hector on June 20th, 2022, and the petition was approved on June 20th, 2023. Hector's date of birth is July 7th, 2001. Hector would be eligible to file for adjustment of status if his priority date is current, since he recently was admitted on a tourist visa. You look and see that the F2A priority date was current in Chart B in June of 2023, and that the USCIS was allowing Chart B for filing purposes. But hypothetically, Chart B is no longer current for October. What advice do you have for Maria and Hector?
All right, so all we're doing is returning to that same facts in the last hypo, but we're pretending that the October visa bulletin for Chart B is no longer current. Remember, Hector's adjusted age is measured on June 20th, 2023. Why is that? Because that's when the petition was approved, and that's when the priority date was current using Chart B. And he's going to be locked in to the F2A category as long as he's able to file for adjustment within 1 year. But the 1-year period, again, started on June 20th, 2023. We know that he can't file for adjustment of status now. Here we are in October because Chart B is no longer current. If Chart B does become current sometime before June of 2024, then he's fine. He's okay because he can meet that 1-year filing requirement. But if it isn't current, if for some reason it stays retrogressed, then it only becomes, you only calculate that age again once Chart B becomes current. But that's not going to help Hector, because remember, he aged out on July 20th, 23. So if you're going to recalculate him, and now we're into 2024, he's out of luck. All right. He would no longer be in the F2A category when Chart B becomes current after June of 2024. Again, because he's going to have to recalculate his age, he would automatically convert to the F2B. And here is the simple template that we use, right? You're pretty familiar with that. Got his date of birth, 1-year petition pending. Add that to his date of birth, and you get an age out on July 7th, 2023. He was under 21 on June 20th, 2023. But unfortunately, under this hypothetical, there was retrogression in Chart B. So while a new new 1-year window opens up, it has to open up before June of 2024. Otherwise, Hector's going to age out. All right. So that's it for retrogression. Hopefully you never have to deal with that, but here we are in the days and the age of retrogression, so it's quite possible it will become an issue. Let's talk about opt-out. We mentioned this initially in the beginning, but let's sort of describe what we're talking about for people whose petitioner naturalizes, and that tends to complicate matters. Christina, you want to sort of give us an overview of how opt-out works?
Sure. So, as we know, under the law, a relative petition filed by a lawful permanent resident for an unmarried adult son or daughter, that's the F2B category, that automatically converts to the F1 first preference category when the petitioner naturalizes. That happens automatically by operation of law. And so we generally think that naturalization of the petitioner will benefit the beneficiary, but if you look at the visa bulletin, the F1 category is often backlogged further than the F2B, resulting in a longer wait to immigrate for that son or daughter. Right now, the F1 category is backlogged farther, except for the Philippines in Chart A. So the CSPA attempts to eliminate this problem, this disparity, by allowing these beneficiaries to elect whether they want to automatically convert to the first preference or they want to opt out of that conversion and stay in the F2B category. So how does the beneficiary make this election to stay in the F2B category? Well, if the client is in the U.S. and eligible to adjust status, he or she can file the adjustment with USCIS and make a written request to opt out of the conversion to the F1. If the beneficiary will consular process and the petition's already been sent to the Department of State, to the NVC, the beneficiary should make a request through the NVC website, go to the public inquiry form on the NVC website, make that request, and then that request will be sent to USCIS because USCIS has to make that decision, but they will make that decision in the affirmative. They will allow the person to opt out. Okay, so that is opt out. Let's see.
All right, so I'm going to jump in here and really sort of summarize what goes on when the petitioner naturalizes. And I tell you, this is the last complicated area of CSPA, right? So that's the good news. So a little bit of review here. What happens? The child is under 21 using his or her biological age. When the petitioner naturalizes, remember this is fairly basic, they're going to convert automatically to the immediate relative category. And Christina walked you through another couple ways that you can become a permanent resident. Become an immediate relative if the petitioner naturalizes. All right, what happens if the derivative is in the F2A category when the petitioner naturalizes as a derivative? All right, remember, you're going to lose your derivative status, right? What are you? You're nobody. You now fall into nowheresville. You're going to need a separate I-130. You don't automatically convert to anything. So make sure when the petitioner naturalizes and you have a derivative child, that petitioner files a new I-130. Hopefully, files that new I-130 before the child turns 21. All right, what happens if the child is over 21 using his or her adjusted age and then converts from the F2B category to the F1 category, right? Well, that's the exact same scenario that Christina talked about. You now are going to wait to see, is the F2B category going to become current before the F1 category? If true, then you get the option. You can opt out, but you got to wait till one of them becomes current. If F1 becomes current first, then you're not opting out. You automatically converted to the F1. If the F2B becomes current first, then you're going to opt out and stay or go back to the F2B category. Opt out of that conversion to F1. All right, now things get a little interesting. What happens if the child is under 21 using the adjusted age, but over 21 using their biological age? Remember, they converted automatically from the F2A category to the F1 category. The question is, can you opt out of conversion from F2A to F1? And the answer is no. The Board of Immigration Appeals looked at this section of the CSPA and said, wait, there's no mention of F2As. It only talks about F2Bs. So therefore, there's no opt-out. And this is a real serious problem. It happens from time to time. Practitioners contact me and they say, what can we do here? The petitioner naturalized. The child was under 21 using their adjusted age, but over 21 using their biological age. What can we do? And the answer is nothing. The child converted automatically to the F1 category. The F1 category is backlogged much farther than the F2A. And you're going to have to be the one to explain that. to the practitioner, you're going to be really sort of embarrassed a little bit that you went ahead and did this. Anyway, there is one little narrow window of hope, though, and that is what's going on in this last bullet point. The child is under 21, using his or her adjusted age, but over 21 using their biological age. They can't opt out, remember. But in certain circuits, and here we are, we're talking about the Ninth Circuit and the Second Circuit, they have interpreted this as saying, well, they were under 21 using their adjusted age, and that's what we're going to use. We're going to be age equals adjusted age. The adjusted age after applying their CSPA formula, not the biological age. Therefore, if the child qualified for the F2A category on the date of parent's naturalization, that child also qualifies as an immediate relative based on that naturalization. So the fact that Congress did not allow for opt-out from the F2A to the F1 only really strengthens their argument that Congress must have known what it was doing. Obviously, Congress had no idea what it was doing, but that's what you do when you do statutory interpretation. All right. Note that these two decisions, though, only apply in two judicial circuits. One is the Ninth Circuit. So if you happen to have the petitioner naturalized in Alaska, Arizona, California, Hawaii, Idaho, Montana, Nevada, Oregon, Washington, Guam, or the Northern Mariana Islands, then you're in luck. If you are in the Second Circuit, that means you are living in Connecticut, Vermont, and New York. And it's the jurisdiction where the petitioner naturalizes that controls, not where the beneficiary is residing. Let's do an example here, just so you can feel like you maybe understand this. Carlos, a lawful permanent resident, filed an I-130 for his daughter, Juana, when she was 20 years old. Petition was pending for 1 year. Juana was 21 when the petition was approved, but only 20 using her adjusted age. Unfortunately, the priority date did not become current in Chart A for 2 more years, and Juana aged out into the F2B category. Remember, Juana is immigrating. She's consular processing. Before she immigrated, what happened? Carlos naturalized, right? So Juana, who was in the F2B category, converted automatically to the F1 category, right? But then what happens if the F2B category is current now using Chart A, but not in the F1 category? What can she do? Well, she does what Christina indicated she can do. She opts out. She follows that whatever the NVC procedure is for declaring that she wants to opt out. NVC has a way of changing its mind as to how you do that. So you got to just make sure that the NVC, you're following that instruction. Let's change it though. Let's change it so that what's happening? Carlos, a lawful permanent resident, filed an I-130 for his daughter Juana when she was 20 years old. Petition was pending for 2 years. Juana was 22 when the petition was approved, but only 20 using her adjusted age. And the priority date was current in Chart B at that time, right? So she's adjusting status. Remember, you're using Chart B, not Chart A. Before she filed for adjustment, though, what happened? Carlos naturalized, right? So you're thinking, oh boy, that's bad news. Okay. So what happened if Carlos is residing in California? Or another state in the Ninth Circuit, or residing in a state in the Second Circuit, then Juana automatically converted to the immediate relative category on the date of Carlos's naturalization. She was under 21 using her adjusted age. That's great news. But what happens if Carlos was residing in Texas when he naturalized, or any of the other circuits other than the Ninth or Second? Then she converted, unfortunately, to the F1 category. You're using her biological age, not her adjusted age. And the F2A, when she naturalizes, can't opt out of conversion to F1. All right, so that's the bad news and the good news, I guess. Now we're going to turn away from family-based immigration. And for the next, 15 minutes, we're going to talk about number of other issues. We're going to go fast because frankly, they're not really all that hard. Christina, why don't you walk us through what happens to refugee and derivatives?
Sure. So just as you probably know, the children of a principal refugee can be admitted as a derivative refugee. They may accompany the principal or they may follow to join later. And the principal refugee can file a Form I-730 for a derivative child within 2 years of admission as a refugee. Well, to benefit under the CSPA and remain a derivative, even if the child's biological age is over 21, then you just have to show that the child was under 21 and was listed on the Form I-590, that's the refugee application, and was under 21 when the principal was interviewed, the principal refugee, because the date of filing is considered the date of interview with USCIS. And if the child was under 21 at that time and unmarried, that child's age is going to be locked in as of the date of that principal applicant, principal refugee interview for refugee status. If not listed on the 590, you may be able to overcome this by providing evidence establishing a parent-child relationship, including evidence of the child's age and a reasonable explanation as to why the derivative was not included on the principal's Form 590. And just keep in mind also for adjustment purposes, derivative refugees, they don't need to actually remain children. So they can be over 21, they can be married, and they could still adjust as a refugee. Also, the principal may have naturalized or may be deceased, and that derivative could still adjust as a refugee. So that's refugee. What about for asylees? Well, it's similar. Asylum applicants, as you know, can include unmarried children under 21 and unmarried. And if that child is under 21 on the date 589, the asylum application is filed and they're named on that form, then they are going to remain a child throughout the process, even if their biological age is over 21 when the I-589 is adjudicated. And the date of filing is when USCIS receives the 589, or if the principal applicant is in removal proceedings, then it would be the Executive Office for Immigration Review, the immigration court. Just with derivative refugees, they cannot be a derivative if they marry, so they have to remain unmarried. And there is a difference between the adjustment of a derivative asylee versus a derivative refugee. In order for a derivative asylee to adjust status, they have to remain a child. So under CSPA, they would remain a child, but they have to be unmarried, and the principal must still be alive and must have not naturalized. So those are the rules in a nutshell for refugees and asylees. Let's turn now to widows and widowers.
All right, so what's a widow or widower? Well, it's defined as the deceased spouse of a U.S. citizen, right? You're married to a U.S. citizen. That U.S. citizen dies. Within 2 years, you can file what's called a self-petition. That's an I-360 petition. Or if an I-130 was already filed on your behalf, then that I-130 automatically converts to an I-360. It's called a self-petition because, of course, the petitioner doesn't have to be alive. The interesting thing is that children retain their child status under 2 scenarios. One, when the I-360 petition is filed, they have to be under 21 and unmarried. So that locks in their immediate relative status. The other thing is, if an I-130 was filed, even if they weren't, I-130 was filed on their behalf, then their status is locked in on the date the petitioner died, right? Because that's the date the I-130 automatically converts to an I-360. The thing to remember here is with widows and widowers, the derivative children are derivatives, even though they are immigrating as immediate relatives. And what's the definition of derivative? It's under 21, unmarried, of the principal beneficiary in the preference categories. Here we're talking about an immediate relative parent, and you have a derivative child. So what's interesting here is that child does not have to meet the definition of a stepchild, right? The child could have been 18 or older, under 21, on the date the marriage happened. Therefore, they're not a stepchild. So the U.S. citizen deceased parent couldn't have filed an I-130. Nevertheless, when that U.S. citizen step-parent, whatever, dies, as long as that child is under 21 on the date the I-360 is filed, or the date of death if the I-130 was there, they retain that derivative status. They might have actually been a stepchild, but let's say the U.S. citizen step-parent didn't even want to file an I-130. Nevertheless, they become a derivative when that I-360 is filed by the parent. All right, let's do VAWA. And we're getting close to the end here. Christina, what goes on with VAWA?
Sure. So as you may know, the general rule in family-based immigration is that immediate relatives can't have derivatives that can benefit with them. But under VAWA, the Violence Against Women Act, the children of immediate relatives can be included as derivatives. And under CSPA, their age is going to be frozen on the date the I-360 is filed. And also, a child will remain a child if under 21 when an I-360 is filed by that child if there's an abusive parent, and that abusive parent is a United States citizen, so that's an immediate relative category. For derivative children, the derivative child will remain a child if adjusted age, again, is under 21, and the abusive spouse is an LPR, so that's the F2A category. And you would do the same calculation that Charles talked about with family-based immigration with the I-130. You're going to use the biological age minus the time that that I-360 was pending to get the adjusted age, and you calculate that age when the either the priority date is current, if adjusting status, which is most likely the situation, is going to be current using Chart B. If USCIS is allowing Chart B, but it has been allowing Chart B for several years now, and hopefully will continue to do so. And just as with other types of petitions, you have to make sure that your beneficiary satisfies the 1 year seek to acquire filing requirement if adjusting and if proceeding under the adjusted age in order to preserve CSPA protection. Okay, let's now talk about Afghans.
All right, this is the last issue. It's not that difficult. We're really sort of applying the same kind of principles. This came up when Afghans started getting permanent residency based on the special immigrant visa category. We hadn't really thought about it until then. But what's going on here? Well, the derivative children can use their adjusted age. And how do we calculate their adjusted age? Well, with the SIV process, it starts by filing the I-360, including the derivative children on that I-360. And the adjusted age is calculated when? It's the biological age minus the period of time the I-360 was pending, right? So you're familiar with that. Everything looks good. The problem is you also have 1 year to file for either adjustment or pay the immigrant visa fee once that priority date is current and the petition is approved. And this could be a problem with children who are overseas and they can't get to a U.S. consulate, for example, in Afghanistan. Remember, Christina talked about the various options on meeting that 1 year filing requirement. And one of them was filing this form I-824, particularly when the petitioner has filed for adjustment of status. We would encourage filing an I-824, which again satisfies the one-year filing requirement for any children who are overseas and can't meet that requirement. Let's do a little hypo here. It's kind of long, but it does kind of ring a familiar tune here. Azim, an Afghan interpreter, filed an I-360 seeking SIV status on July 3rd, 2021. He listed his spouse and daughter on the petition since his daughter was unmarried and under 21. Petition was approved 20 months later on April 3rd, 2023. Priority date was current at that time. Azim was paroled into the United States with SQSI status. He recently applied for adjustment status. His wife and daughter stayed behind and are still hiding out in Kabul. The daughter was born on February 1st, 2001. Using her biological age, she'd already turned 21 on the date the I-360 was approved. But as you well know, we use her adjusted age. She can add 20 months to her date of birth or subtract that from her date of, age on the date the petition was approved. She would turn 21 on October 1st, 2023, and was under 21 when the petition was approved. Fortunately, Azim filed an I-824 with the I-485 to satisfy the daughter's one-year filing requirement. So he locked her age in on that date. Well, big congratulations to all of you who have lasted this long. It's pretty complicated, as I promised. We hope we've made it a little bit simpler. I hope we haven't confused you even more. You do have a lot of handouts. You've got these slides as handouts. You've got 3 other articles we've written on this issue. There's a book out there that's written by me and published by AILA, Focus on the Child Status Protection Act. I'm in the process, actually, of course, of updating it, so don't buy it yet, but it should be available early next year. We also have a lot of materials on our website. We encourage you to go there. This webinar, of course, was recorded, so you can listen to it as many times as you want. And then finally, we have 43 questions on the Q&A box, none of which we got to. Maybe we got to some of them, but there's 43 just still hanging out there. Feel free to send me those if you want, or any future questions that arise on this area. I actually am one of these weird people who likes answering these kinds of questions. So feel free to send them to me. You see my email address up there, cwheeler@cliniclegal.org. And that's it. We're a couple minutes over, but I hope you forgive us. Christina, thank you so much for hanging in there as well and participating.
Thank you. Thanks, Charles. Thanks, everyone.
All right. Take care. Bye-bye.
Bye.